I'm Tristan Morrison with Morrison Hughes Law. We're here with Kate Hayden today. She's our criminal defense, criminal justice attorney. She's here to walk us through the process all the way from arrested in handcuffs to not guilty. So let's start off right at the beginning. Getting arrested. What's it like? Is it nearly as fun as it seems?
No fun at all to be had with the arrest process. So an arrest begins when a police officer has probable cause to arrest you, meaning they have some amount of evidence to believe that a crime was committed and that you were the person who committed that crime. You know, when they encounter you, if they're called after the fact, whatever the circumstances are, once you're taken into custody, handcuffed, transported to the jail, all that sort of fun that you often see in movies, on TV, things like that. And you'll be booked into the jail. That process is, you know, them taking fingerprints, photos, putting all your information in, and that's sort of how we get from the alleged crime that happened to, all right, now you got a case.
Yeah, and all kidding aside, that sounds incredibly stressful.
Yes.
What kind of tips can you give to somebody who is being arrested in terms of what they should do and what they should expect?
So the number one thing that I always tell people is you have the right to remain silent, use it. Keep your mouth shut. You are not going to talk yourself out of anything. Trying to explain yourself and trying to argue with them is not going to help. So just do your best to stay calm. Just let the process unfold, let them do their jobs, and then get an attorney. You deal with all the other issues after the fact.
Okay, but how do you even get an attorney? If you've been arrested, you know, is it true what they say that you have a right to like one phone call? And if you do have one phone call, who do you call?
So they are going to let you make a phone call once you're actually booked into the jail and that process starts. Chances are you don't know a lawyer's phone number off the top of your head, and that's okay. Calling a family member is a perfectly valid thing to do. They can sort of get that ball rolling for you, and so that way at least somebody knows where you are and what's going on.
They have a lawyer's phone number. It's 404 Latte. There you go.
There you go. Now you do.
All right. So let's assume that you're not going to call the lawyer right away. You want to call a family member, and what's the family member have to do? Do they have to call a bail bond company, or what's next?
So once you are actually booked, within the next 24 to 48 hours, usually you will go in front of a judge for what is called your first appearance. That is where the judge will look at the charges that you were actually arrested for, make sure that there actually was some kind of probable cause for that arrest, tell you what those charges are, and set your bond. In the vast majority of cases, there are a few extreme exceptions where the judge either would deny bond or would not be able to set bond. It would have to go in front of a different type of judge.
Okay, so using your first phone call to call a bail bonds company wouldn't make a lot of sense because your bond hasn't been set yet.
Correct.
Okay.
Yep.
So maybe a trusted family member or a friend who can begin the process of helping you get in touch with an attorney and with a bail bonds company so that when you have your first appearance in front of the court, at that point, you're ready to go.
Right.
Let's talk a little bit more about the bail bond process and what you can expect or what your family member can expect when they're talking to the bail bonds company. What does that look like?
So they really will walk you through that process once you call them. They're obviously professionals. It's what they do every day. They're going to need to know, where your loved one is, what the bond is. There's going to be a lot of paperwork back and forth. They also all have their own different policies in terms of what fees they charge. Typically, a bonding company will charge between 10 to 15% of your bond, and that's the money that you're going to have to come out of pocket for them to actually go and bail you out.
Why is it so expensive? Would it be because if you don't show up for your hearing or your bond hearing, would it be because, in the event that you skip bail, then they're out that money because they have to put up the entire amount of your bail, right? So if you disappear, that money's gone and they're going to send a bounty hunter out to find you.
Bonds can be posted in one of two ways. If you can afford the entire amount of your bond, you can post what's called a cash bond, and you don't have to go through a bonding company to do that. You are literally posting your bond at the sheriff's department, 100% of whatever it is. So if it's $5,000, they are holding your $5,000.
So you could literally show up with a briefcase full of money, just cash like in Better Call Saul. Show up with stacks of $100 bills and you give that to them, and then they'll have to give it back to you if you show up for your bond hearing.
At the conclusion of your case is when you would get that.
At the end of the case.
Yep. So they hold that money. Wait,
what if you're convicted? You get it back still then, right?
Because you've never had your bond revoked.
Right?
Yep.
Okay.
Yep. So the bond is set as a financial incentive to make sure that you appear in court. So as long as you appear in court, go to all your court dates, don't do anything to have your bond revoked, like violate any of the conditions that are set on your bond, you would get that money back if it's a cash bond. Now, if you go through a bonding company, you don't get any money back at the end of it. The money that you pay to the bonding company is that's a sunk cost. You're not getting that back, but they are posting the remainder of your bond, and they get that money back, assuming that you do it. So you come less out of pocket.
Sure, it's like, the average American has, $500 in their bank account.
Right.
You are in a situation where you can't pay the entire bond, cash bond yourself, so you need a bail bond company to step in and vouch for you. Mm-hmm. And that's why if you end up disappearing to Canada, they're going to send out the bounty hunters.
Right.
Okay.
Right, exactly.
All right. When I walk into a bail bonds company and I've got a family member who's in jail, like, what are the surprises that I'm likely to run into? Like, what kind of things might I encounter that I wasn't expecting?
Things can often get a little bit tricky. It really comes down to money, honestly. If you've got the money in hand and you can, put up your part of it, you really shouldn't encounter anything too tricky. Now, if you're dealing in a situation where there is a very, very high bond set, I'm talking like $200,000, $300,000, things like that, you can do what's called a property bond and actually put up property that you own as collateral to post that bond. That can get a little tricky. Jurisdictional things with that can get tricky because if the property is not in the county where the case is,
okay, yeah,
you have to jump through several hoops in where the property is located and getting it back into the jurisdiction where you are to actually get that bond posted.
Okay, that's interesting. So let's talk for a minute about what the judge might consider when they're setting your bond, when they're deciding exactly how much you're going to have to come out of pocket. Mm-hmm. What do they think about?
So there are set considerations in Georgia about it, and this is a very individualized question. Okay, so they're going to look at, are you a flight risk? Do you have ties to the community? Are you a risk to commit any, future felonies or anything? Are you a risk to intimidate witnesses, or those types of issues in the particular circumstances? The biggest issues are going to be, what are your charges? How serious are they? And what's your history like? Do you have a criminal history? Have you ever been arrested before?
Okay, so they're going to look at your entire, like your rap sheet, the whole background search of what you've done in the past. Do they have access to like what other states know?
Yes.
Okay.
So the state, being the prosecutor's office, does. There's they can do what's called an NCIC. It's a national criminal history search. There's also a Georgia-specific one. So when you go in, they'll run your name and they will have everything that you've ever been charged with anywhere in the country.
Okay, so if I've committed a bunch of crimes in Florida, they're going to know about it.
Yes.
Okay. Can you give me some examples of like what you would expect to see as a former public defender and now representing people in private practice? Like, what do you usually expect to see from a judge in terms of bond on like a DUI?
So again, this can vary widely depending on the jurisdiction that you're in, as well as the particular facts of your case and your history. So, but on something like a DUI or, other similar traffic offenses, reckless driving or things like that, on any misdemeanors, I would anticipate something in the range of $3,500 to $5,000.
Okay, so it can be as low as like $3,500 if it's your first DUI, or if there was no injury associated with the wreck. But if it's your third DUI and maybe somebody got hurt in the wreck,
right,
then that bond's going to go way up.
Exactly.
Okay.
Yep. And especially for much lower level offenses, again, misdemeanors, things like that, and for somebody who has no history, has ties to the community, isn't a flight risk, judges also have the option to release someone on what's called their own recognizance. It's OR bond, a signature bond, or some of the colloquial terms for it, or an unsecured judicial release is now the formal term for it. And that's literally you sign yourself out of jail. There's no bond, there's no money. They are releasing you on your promise that you're going to show up.
Well, that's the bond we want.
That is always the ideal bond, but judges are very hesitant to give those out.
What are some of the things that you can tell a judge to help try to persuade the judge, hey, this person should get an OR bond?
That really comes down to, again, if there's no criminal history, that's usually a very persuasive factor. If the charges are not particularly serious, if no one got hurt, things like that, someone with a lot of ties to the community is something that judges like to see, because that means that person is here. They're going to stay here. They're going to be here. If something goes sideways, we'll be able to find them. They're not going to disappear.
Just for fun, What is the worst crime you have ever heard somebody accused of where they got an OR bond?
Aggravated assault.
Okay.
I got someone an OR bond on an aggravated assault.
What makes an assault aggravated as opposed to just assault?
The use of a weapon, typically.
Okay.
There can be some other things, but typically there's some sort of weapon used. Now, when I say weapon, they interpret the definition of that very liberally.
Sure, you threaten somebody with your hair comb.
Yeah. I've seen a book. I've seen the floor. I've seen hands. I've seen a wall. All be listed as weapons.
On behalf of lawyers everywhere, a book can be a weapon. So, okay, wow, that's impressive. You got somebody out on an OR bond for aggravated assault.
Yes.
We're gonna look for more of that.
Yeah.
Now you've said that you can do that. Everybody's gonna expect it.
It can't be done in every circumstance, but